Welcome to Cartoonist Kayfabe. My name is Ed Piskor.
I'm Jim Rugg.
And the courtroom is in session, or more accurately, the deposition hearings, or whatever you want to call that, between Neil Gaiman and Todd McFarlane's lawyers. We've been unpacking it for a number of weeks. There's still a lot of stuff to go through, and it doesn't stop in being fascinating. First off, before we get busy, what do you got on the stands or whatever?
First, let me plug Daniel Best.
Yes.
The guy who put this all together. We're pulling it from his blog, but there's also a book, Todd McFarlane versus the World, or Todd McFarlane Against the World, that Daniel Best has authored that details a couple of Todd McFarlane's court cases from the 90s and early 2000s. So if you find this interesting, that's the place to find more information on this. And also, as we have learned, not easy to get all of this legal information out in the public. Takes some real legwork. So thank you to Daniel Best for doing that and making this available, because, as you say, Ed, it is completely fascinating. When we first started looking at this, it kind of blew me away. So many thanks to Daniel Best for that. You can find more of my work at patreon.com/Jim Rugg, where you can download out-of-print zines and mini comics. You can see a lot of my original art process and how I make the comics I make, such as Street Angel and the Plain Janes. These are both available and still in print wherever you buy books. Comic book shops can get them for you, bookstores or online, and make the perfect gifts this holiday season, suitable for all age readers. One is about a homeless ninja on a skateboarder. I don't know who wouldn't like that. One is about a group of high school artists who start doing public art and disrupt their little quiet suburban town. So track those down wherever you buy books for the readers in your life.
Got some news, Jimmy. Red Room Trigger Warnings, issue number 1. That's this cover right here. It's going to come out in a couple of weeks at the beginning. Guess what, man? Paper shortages have pushed back the print schedule. The queue at the print facility is 6 weeks long. So it's going to come out in February. That gives me an extra 6 weeks to promote the issue. So this is the basic cover for the regular standard edition you're going to see on the stands. I want this thing to sell out on day one. So Kayfabers, you see this image, scoop up this comic. It also fell victim to the ransomware issues that Diamond had. So stores couldn't solidify their orders in the standard final order cutoff date. And I don't think there's going to be as many as people are going to be, seeking this thing out. So here's the regular cover. And, I got friends in the game who have contributed cool variants. So there's Peach Momoko's, there's Jimmy's, Zap Comics variant cover. And then I have this other one with the Rat Queens.
Little story giveaway there, right?
That's goddamn right, man. So let's do a little debrief session and launch right into things, because there is a lot of material to discuss and to read from this deposition. One of the things that we discovered last week was this idea of love checks that Todd McFarlane is sending Neil Gaiman. And I just imagine when Neil Gaiman says the word love checks, like there's like a little irony in his voice, a little twang to his voice when he says this kind of stuff. And you read that kind of thing. These are two alpha males running their own businesses, two different kinds of businesses. McFarlane is envisioning this great empire of all of this, his tent poles, as he called them in our shoot interview: toys, video games, cartoon, movie. Like, he's thinking, and he wants ownership of all of that stuff. Neil Gaiman, successful writer who's built a heck of a career for himself, parlays that into outside of comics, novels, all of that stuff. Unfortunately, there are people who run businesses that have underlings who will accept a love check. That's not going to be another person who's running their own business, who's an alpha dog in their own territory. You can't give another boss a love check and expect that they're going to be okay with that. McFarlane, he didn't size up his guy well enough, man. If that in fact is the deal, like if he positioned it as love check to the guy and thought everything was going to be all right because I'm showing you love.
Yeah, and I'll add one more bit of context to this. So, a lot of what we covered was 1997, whenever they really started trying to, get a contract. Neil Gaiman really started pushing for this contract. Angela miniseries, television show, all this stuff's happening, and he's trying to get this in print. And this is a time whenever the comics industry has just collapsed.
Yeah.
You know, I was thinking like, I think this is around the time that Jeff Smith takes Bone to Image Comics, because things are just so, it's just unknown what is coming next. You know, 1997, when McFarlane's sending out these love checks, you know, we have gone from seeing almost 1 million copies sold of Spawn #9, whenever that's released in 93, to, I don't know what the numbers are, but they might be a tenth of that by 1997. And then the other piece is they're having this deposition in 2002. McFarlane's also embroiled in other legal battles with the hockey player, you know, Tony Twist, that he had named the character after. I'm not sure the dates on that, but what I'm suggesting is that Todd McFarlane, the businessman, there's a lot that he's sort of now trying to like organize, cover, possibly pay for. There's a lot going on here from Todd McFarlane's point of view, and things are just very different than they were in 1993 when this all started, when your love check was $100,000. Now you're getting one love check over several years for a fraction of that amount. It changes the feelings towards those love checks.
The entire court case and legal entanglement between Gaiman and McFarlane fascinates me, because my first Neil Gaiman comic I ever read was Spawn issue #9. Sandman, first off, mature readers, I was 12. I couldn't get my hands on that stuff, technically speaking. And Neil Gaiman, involves himself in the McFarlane world several times, to the point where I associated him as being, you know, firmly entrenched in that space. He did the Angela miniseries. He did another random issue of Spawn. And whenever he was involving himself with McFarlane being the wise marketer that he is, would let everybody know in Wizard Magazine through ad work, through house ads in his comics and stuff. Neil Gaiman is doing another. So I, as a kid, associated the names together. So then as you get older, you discover Sandman, you discover the wider world of what Neil Gaiman has put together for himself. You see that he has his own stuff going on. And it was nuts to see that them get involved in, like, you know, this a legal battle, and that battle has went on for many years of my young life. Like, if I was 20 years old, like, you know, a quarter of my existence, these guys are in the legal trenches together. There's not much more to unpack from the last round. Where we left off, there was another little piece of Neil Gaiman showing you how good of a guy he is, when they're talking about the sort of character briefs, the agreements that DC Comics makes with him, with the characters that he creates. You know, here's the Endless, Morpheus, Despair, Desire, yada yada. What's this strike through for? Oh, that's Destiny. This character existed. You see, I'm a good guy, man. I'm not gonna. I just want credit for the things that I made.
I'm not taking credit for something I didn't do.
Exactly, man. So he's making very clear to let everybody know.
That feels like such a genius piece to be able to put in here.
Yeah.
And it's like, it's McFarlane's lawyer that brings that out, right?
Right.
That's an amazing, that feels like you couldn't have written this better.
So when McFarlane lawyer brings that stuff into court, you leave that part out. You don't ask about that. Yeah. So the way this game is played, Jimmy plays the voice of Neil Gaiman with no British patois like Humphrey Bogart, just the facts. No, that's Dragnet, I think. Just the facts, ma'am. Joe Friday.
That sounds right.
We're just playing it straight. We have multiple parts of the previous depositions in the description directly below this video, but you can really parse out any piece and have a good old time with this, because we're seeing how two of the biggest names in American comics, how they build their business.
A lot of craft as well goes into it, because they're trying to explain this to a judge that doesn't know anything about how comic books are made.
There's the administrative stuff is what's really important to me with this, because listen, let's name some names. You think Howard Mackey has an entertainment lawyer? You know what I'm saying? You think
Right.
Fabian Icieze has agents and stuff like that? Well, maybe he does, but seeing that Gaiman has this back end infrastructure set up, that's how you keep your ducks in a row and you don't get screwed over and have to do press to try to embarrass people into giving you money. Anyhow, I play the voice of everybody that's not Neil Gaiman, and if you're ready to launch into things, I'm ready to launch into things. Where we ended was with Lady Johanna Constantine and how that is a derivative character as compared to medieval Spawn. There's a discussion off the record, and we can launch right back in with Todd McFarlane's lawyer saying, as far as you know, Mr. Gaiman, does Exhibit 57 represent the agreement that you signed with DC Comics in and around the early 1993, February through April of 1993 regarding character equity and the characters listed in the first paragraph of that document?
Yes.
And is it true that you are not presently aware of any other character equity agreements between yourself and DC Comics related to these specific characters? I'm not asking you to say if you know or if you are certain that none exist. I'm asking if you are aware of any others besides this exhibit.
No.
And let me ask you, I don't know if you have a copy of your amended complaint. I brought copies if you need them. Let me just hand you one. I don't know that we need to mark this as an exhibit. And then Neil Gaiman's lawyer pops in. This is the amended complaint. Do you want to look at that, Alan? McFarlane's lawyer. Make sure I've got this right. Then McFarlane's lawyer says, as far as I know, there's only one amended complaint. Gaiman's lawyer says, well, I got the pages copied. It's the one signed at the back. McFarlane's lawyer. Would you take a look at page 11 of your amended complaint, Mr. Gaiman?
Yep.
Do you see paragraph 48?
Yep.
And right above that, there's a subheading with a letter C, and it says the 1997 agreement. Do you see that?
Yep.
I want to ask you some questions about what's being characterized in your complaint as, your amended complaint as the 1997 agreement. And the easiest way to do this may simply be to walk through these paragraphs and ask you some questions, and we will probably refer to some of these documents, okay?
Okay.
In paragraph 48, you allege that you received a memo from Larry Marder of Image Comics setting forth terms regarding royalties for Angela, Medieval Spawn, and Cagliostro, and that was around February 18th, 1997. Do you see that?
Yeah.
Earlier, we were talking about an offer you received from Larry Marder, which you said was significantly less than what it should have been pursuant to the DC Comics agreement, correct?
Yes.
And that, in fact, is the offer that is referred to by Melanie Cook in the letter she sends to Larry Marder attaching the contracts, and that letter was marked as Exhibit 47, I believe.
Yes.
Okay, second sentence in paragraph 48 of the amended complaint states that the written offer was substantially worse than the terms of Gaiman's Sandman contract with DC Comics, contrary to the agreed-upon standard for the treatment of Gaiman under the 1992 agreement. Do you see that sentence?
Yep.
And what I want to make sure that the terms of Gaiman's Sandman contract with DC Comics are, you referring to the Sandman agreement with DC Contracts that we have marked as Exhibit 58, which is the executed version of your character equity agreement.
Not necessarily. That wouldn't have existed necessarily at the end of 92 when those checks came in.
When is the first time you ever got a character equity agreement from DC Comics?
I think this may be the first of the character equity agreements, but it formalized...
I'm sorry, I didn't mean to interrupt.
But it took the April 20th, 1988 contract, amended January 2nd, 1990 and May 20th, 1991, and worked out a formula and put it all down on paper. So as I understand it, that stuff was implicit in the earlier contracts.
But not explicit, correct?
But not explicit. This is the first time it was made explicit.
Is it your testimony that the terms contained in Exhibit 58, which was executed after your 1992 agreement with Todd McFarlane, nevertheless accurately reflect the arrangement you had with DC Comics at the time of your 1992 agreement with Todd McFarlane?
As I understand it, yes. I mean, there may have been, my agent had been negotiating this contract all through 1992, so this was long before Todd ever got hold of me. Marilee had been going backwards and forwards with them, with DC, and figuring out the exact way and shape of the contract. But up until that point, it had not become... When I began doing comics for DC, this was the standard of the comic. This was the kind of contract that one was signing.
Gaiman's lawyer, referring to Exhibit 57?
Referring to Exhibit 57, which is the agreement, is I'm writing a comic for you.
McFarlane's lawyer. And the standard agreement, which you said was embodied in Exhibit 57, which in fact covered your work on Sandman issues 50 through 73, correct?
Uh-huh.
And which also amends and updates the agreement originally presented April 20th, 1988, does it not?
It does.
That's the agreement that is the standard DC Comics agreement in your experience when one simply writes a comic book issue. Is that correct?
It is.
And that?
By this point, we could see that the characters were able to start spinning off, that merchandising and so on and so forth was beginning to occur, which was not happening in 1988 when I signed the original agreement. So that we were putting down on paper how things actually worked so that I didn't wind up phoning them all the time and saying, hey, you just sold the movie rights. What do I get? Hey, you are doing a toy. What do I get? Which is what happened.
So that Exhibit 58 represents the culmination of negotiations between you and your agent in DC Comics as to how you are going to share in the equity of the characters that you've created up through issue 50 of Sandman. Is that correct?
Yes.
And that your negotiations with DC Comics, that culmination in Exhibit 58 were taking place, sounds like, during and after the time that you entered the 1992 agreement with Todd McFarlane regarding issue 9. Is that correct?
It is.
So is it fair to say, when referring to paragraph 48 of your complaint, that when you say that the agreed upon standard for treatment of Gaiman under the 1992 agreement is embodied in the terms of Gaiman's Sandman contract with DC Comics, are you referring to Exhibit 57 or are you referring to Exhibit 58?
I would be referring to the entire run of Sandman contracts and going back to the 1988 one, which only gives me character equity and ownership if I complete the first 12 issues, for example. There is a clause in there that I get a share of that, of the characters in that issue.
Is it fair to say that, in fact, there really isn't a standard DC Comics contract right at the end of 1992 that has always governed your relationship with DC Comics? In fact, isn't it fair to say that based on at least 3 amendments of an agreement you signed in 1988 with DC Comics and another agreement which you negotiated through 1992 that ended up in the character equity agreement in Exhibit 58, that your participation in royalties, etc., with DC Comics changed over time? Isn't that true?
Absolutely.
Do you see my problem here, though? Is you've got an allegation against my client that he agreed to treat you a certain way, and in 1992, you have already testified that in 1992, that's all that was said. There was no discussion of what percentage of royalty was gained, what was done with this character or that character, what was going to happen with the toy, so that in 1997, when you are sending documents to Mr. McFarlane to explain what was meant by your DC Comics contract back in 1992?
Certainly. They were the grounds from which we were negotiating our deal.
I understand, but let me ask you this. Is it true that you never told Mr. McFarlane in 1992 what percentage of royalty you got based on licensed products?
Yes.
Is it true that you never told Mr. McFarlane in 1992 what percentage royalties you would get from DC Comics based on reprints?
Yes.
Is it true that you never told Mr. McFarlane in 1992 what percentage of DC Comics would pay you as a royalty for trade paperbacks?
I have already testified that Mr. McFarlane and myself didn't talk percentages back then.
But in 1997, now you are telling Mr. McFarlane that he agreed to match a DC Comics contract. Is that right?
No, I'm not saying to him he agreed to match a contract. I'm saying to him he agreed to treat me as well or better than DC, and this is how DC does it. Let's talk, let us negotiate.
All right. Well, then maybe I'm misunderstanding you. Are you in 1997 negotiating for the first time what the royalty rates should be for the use of Angela and Cagliostro in Medieval Spawn?
In 1996, as far as I'm concerned, we are memorializing and getting exactly into putting on paper for the future a deal that we have, which is that Mr. McFarlane will treat me better, as well or better than DC would have done.
I understand that, and I know it sounds.
And so we are obviously, this is an abstract concept, we are attempting to attain an abstract contract. I'm not trying to put one over on Mr. McFarlane. I'm trying to say, okay, I have grabbed a contract. These are the figures.
Let me stop you right there. and I think it's important for us to try to do the best we can right now in letting each other finish our questions and answers.
Sorry.
That's all right. I'm doing it too. I just want to make sure that I've got this clear. You said in 1996 you were memorializing what you both meant back in 1992 when you said, treat me better than I get treated at DC Comics. Is that right?
Uh-huh.
And that back in 1992, the only specific statements you testified that Mr. McFarlane made regarding being treated better than at DC Comics was that he wasn't going to ask you to sign your rights away. Is that correct?
I think there were a lot more. I mean, if you were going to say specific statement, Mr. McFarlane said a lot more than that.
I'm talking about what he said about all the good reasons you should do it. I realize that, but I'm talking about specific terms that you agreed on. As I understood your testimony earlier today, and you've just repeated it here, you did not talk about a 7.5% royalty or a 15% royalty or any other royalty figure for any use of any characters or any reprints of any issues. Is that correct?
Yes.
In 1992 question?
It is.
But in 1996, you are attempting to memorialize in writing what you meant by that back in 1992. Is that correct?
In 1996, I'm just trying to get something down on paper that I feel is analogous to a DC deal, the kind of figures that I would have been getting from DC Comics.
And my point is, well, let me ask you this. In your complaint on page 20, you've got a claim in the middle of the page. It says, count 4, breach of contract. Do you see that?
Uh-huh.
And in paragraph 76, you state, and I will quote, McFarlane and McFarlane corporate defendants breached the 1992 and 1997 agreements by, inter alia, failing to pay Gaiman the agreed upon royalties for exploitation of Angela intellectual property and the intellectual property held by Gaiman, unquote. Do you see that?
Yep.
And in paragraph 77, you state, quote, McFarlane and McFarlane corporate defendants breached 1992 and 1997 agreements inter alia, interfering with Gaiman's right to do and commercially benefit from publishing, quote-unquote, one-offs, and by interfering with Gaiman's right to do and commercially benefit from a Randy Bowen design Angela statue, end quote. Do you see that? We got Randy Bowen makes a cameo appearance in the gimmick.
I do.
And you state in both paragraph 76 and paragraph 77, you allege breaches of the 1992 agreement. Okay? Do you see that?
Uh-huh.
All right. And I'm really trying to find out what part of the 1992 agreement has Mr. McFarlane and McFarlane corporate defendants breached.
Are you asking me a question?
I am asking you a question.
Okay.
Explain what you mean by paragraph 76, leaving out reference to a 1997 agreement. I want to know how the 1992 agreement was breached.
Mr. McFarlane did Angela toys. These were brought out, I believe, in the spring of 1994 and were very, very popular. He did various models of them, including a 12-inch high Angela toy and a red Angela toy and a cosmic Angela. No payment of any kind were made on these until we finally got to the 1997, the payment that signified that the 1997 agreement had started, nor was there any attempt.
Let me stop you right there. How much has Mr. McFarlane supposed to pay you under the 1992 agreement? What percentage royalty was Mr. McFarlane supposed to pay you pursuant to the 1992 agreement as royalties for Angela toys? Gaiman's lawyer pops in, if you know. McFarlane's lawyer, well, look at the documents. I mean, you've said that the DC Comics deal, you got all the character equity agreements. I'm just trying to find out here where we can do it. I don't want to get short with you. I really don't, but you've got a certain amount of time left, and we really need to kind of pin this down. So if you could point to me what document I should be looking at, what document Mr. McFarlane should be looking at to say, oh, I should have paid him 50% of net.
Mr. McFarlane managed to make it work for the medieval Spawn toy.
That's not my question.
I know, but I'm saying I got to check.
That's not my question. Tell me what percentage royalty Mr. McFarlane is supposed to be paying you for the Angela toys under the 1992 agreement.
Under the 1992 agreement, a payment.
Doesn't matter how much.
Well, as long as it is in some way reflected a fairish share of what I would have, of something that Todd felt fair, I would have been fine on it. Nothing came in, and it became more and more obvious nothing was going to come in.
And why would you have been satisfied with just something fair? Is it because you never had agreed on a royalty rate?
I trusted Todd.
That's not my question. Did you agree on a royalty rate in 1992?
No.
Gaiman's lawyer pops in. Object, as he's answered that already. McFarlane's lawyer. What was the Randy Bowen design Angela statue?
Glad to get back to Randy Bowen. Randy Bowen is the top guy in comics when it comes to doing statuettes, high-end things you can put on, the corners of tables and so forth, not toys, $150 porcelain kind of things. And he approached me at some point in the 90s and said he would really, really like to do an Angela toy, an Angela statue. And, he thought it will be cool and that obviously I would make some money out of it. And I said that was a lovely idea and to contact Todd. And as far as I know, he never heard back from Todd.
So how did Todd prevent you from benefiting from a Randy Bowen design Angela statue?
If Todd had given his approval on it, he would have gone into, Randy would have made it without Todd's approval, without any communication from Todd.
Did Randy need Todd's approval, in your opinion, to make the statue? Gaiman's lawyer pops in. Object to the extent it calls for a legal conclusion. McFarlane's lawyer pops in. As far as you understood, you told Randy Bowen to go talk to Todd. Why did you do that?
It seemed polite.
Do you believe Todd had an obligation under the 1992 agreement? Well, let me step back. What time was this? What time period did this happen?
I don't know.
You said sometime during the 90s. You can't remember?
Sometime during the 90s, I can't remember.
That's a long decade. Let's try to pin it down. Was it before you went to Phoenix or not?
I think so.
By the time you leave Phoenix, you're not in a great relationship with Todd. Is that correct?
No. By the time I leave Phoenix, I figure everything is sorted out again.
Then 6 months, you get the offer and you realize things are not sorted out. Is that correct?
Yes.
You learn from Larry Martyr that Todd's asked Larry to talk to you about it. And my question is, when Randy Bowen comes to you, is this before you have gone to Todd and said, hey, I'm not getting any royalty from this stuff. What's going on?
Yes.
So it's well before any 1997 agreement. Is that correct?
Yes.
Do you understand that Todd, at any time in 1992, in a 1992 agreement, made a promise to you that he would make certain statues of these characters?
Absolutely not.
So even if Todd had been paying you royalties all along, you wouldn't say that there is anything in the contract that said Todd should have made the statue with Randy Bowen. Is that correct?
Yes.
What are publication one-offs?
They are comic books or possibly trade paperback originals, not to be confused with one-shots.
You have to help me on that one.
I'm sorry, I'm just pulling my thoughts together. A one-off could be anything from a trade paperback original or a hardback original to a series. Angela was a one-off. It's not an ongoing series. It's something that happens probably 6, maybe 8, 12 issues is probably as far as you could go and say something was a one-off.
Before it becomes its own series.
After that, it becomes its own series.
In paragraph 77, you state, quote, McFarlane and the McFarlane corporate defendants breached the 1992 and 1997 agreements by, inter alia, interfering with Gaiman's right to commercially benefit from publication one-offs. What do you mean by that?
What I mean specifically as part of the 1997 agreement was what we tied everything down is one of the things that Todd gave me to make up for, do you remember I mentioned earlier the Angela Glory and the Medieval Spawn Witchblade comics that other Image houses did? So Todd said, look, I can't pay you anything for those, but what I will give you is the right to go and do a one-off, a one-shot payment with other comic companies using Angela or Medieval Spawn. So if I want to do Medieval Spawn Batman, I could, and I could have done Medieval Spawn Batman as a 120-page graphic novel, or I could have done it as a series of 4 comics or whatever. And the same with Angela, where if I had wanted to do Angela Meets the X-Men, I could have done 4 issues of Angela Meets the X-Men, whatever. Or if the other idea was if I wanted to do an Angela series or a Medieval Spawn series, I had to do it with another Image. I had to do it at Image. If it was a team-up, I could take it to another company, and that was Todd's agreement in 97.
Is that the same as a crossover?
Not quite, because what you were talking about, a crossover could occur in a regular comic. A crossover basically is what happens when 2 characters cross over. They intertwine. You get a Sandman, turns up in Spawn, that will be the famous Sandman-Spawn crossover or whatever.
How is that different from Medieval Spawn Batman one-off? Is that because of where it appears?
It's the way it gets published. It could conceivably be a crossover, but a crossover tends to, we are really into comics trivia, but it tends to imply that you have done, you had a story over here and you have a story over here and now they cross over. The Angela series, the 3-issue Angela series I did could have been considered a Spawn crossover because Spawn is in it, but it wasn't actually Spawn. It was Angela and Spawn was a character in it.
Now, if you look at Exhibit 58.
You asked me the question I don't think I actually answered. You asked me how they had breached it.
Yes.
Okay, I had...
Well, let me stop you. I think you did say, and let me just make sure, you stated that in the 1997 agreement, because Todd had said there were no royalties to give you based on sharing of the characters with Image Comics, that he would have to make that up to you by allowing you to do one-off Angela and a one-off with Medieval Spawn. Is that correct?
Yes.
And that, in fact, in breach of that 1997 agreement, according to your allegations here, he did not let you do that. Is that right?
What happened was I spoke to people at Marvel Comics and at DC Comics about doing these comics. They were very enthusiastic at the time, and when they phoned Todd, nobody would put them through to him, and he didn't return calls.
Did you hear from anyone at DC Comics or Marvel that Todd specifically said you could not do one-off with DC or Marvel?
What I heard was that Todd would not return calls.
And is it your understanding that DC Comics and Marvel needed to get permission from Todd before they would agree to do one-offs with you containing the Medieval Spawn or Angela character?
Both of them would want, yes.
Why is that?
Obviously, they only have my reputation. Otherwise, they only have my representation that this is an agreement with Todd, and they are going to want to hear it from Todd. Yes, it's okay. They are not going to go ahead and publish Medieval Spawn Batman without knowing that it's going to be Todd. Otherwise, they would run into trouble further down the road.
Why would they run into troubles? Because they realized Medieval Spawn was a character owned by Todd McFarlane? Gaiman's lawyer pops in, object, call for a legal conclusion or lack of foundation. Then McFarlane's lawyer says, you can answer.
I don't actually understand the question.
Well, you just said that DC and Marvel would not do the one-off with you without knowing that Todd had given you permission to do so. Is that correct?
Uh-huh.
And I'm asking if you know, based on your 15-plus years in the comic book industry, why DC Comics would believe, or Marvel Comics would believe, that it needed to get Todd's permission rather than just yours to do one-off with Angela or Medieval Spawn.
On the case of Medieval Spawn, Todd is the holder of the trademark. I imagine holder of all Spawn copyrights, and they're going to want to know that it's completely okay. They don't want to run into problems somewhere down the line.
Would the same be true of Angela?
I don't believe that Todd owns all copyrights on Angela, but again, Todd is obviously the co-creator of Angela. Todd has previously been the publisher of Angela. You don't want to, the last thing you want is the polite little letter from the lawyer letting you know that you cannot send a comic that you have already prepared to press.
And I just want to get from you the specific actions that McFarlane took, and you got this allegation against other McFarlane corporate defendants. I just want to be clear. You have this allegation both in paragraphs 76 and 77 that both McFarlane, meaning Todd the individual, and the McFarlane corporate defendants breached these agreements. Do you see that in your complaint?
Uh-huh.
How did TMP International breach your 1992 agreement? You didn't have a 1992 agreement with TMP International, did you?
As far as I know, I didn't.
You didn't have a 1997 agreement with TMP International, did you?
I don't know. I would have to go back and look at the stuff that was signed. I don't know whether that was as all defendants.
We will do that in a second.
Okay. Having dealt with Todd McFarlane, watched Todd's deposition, and watched Todd now speak, I'm speaking as he said. Always assume I'm speaking as TMP.
Did you make these allegations in your complaint before Todd's deposition?
Yes.
No, Gaiman's lawyer pops in. Object. Argumentative. The lawyer drafted the complaint. Let's take a break. Short recess is taken. You've alleged that Mr. McFarlane and the other McFarlane defendants breached the 1997 agreement. Is that correct?
Yes.
I would like to talk about the 1997 agreement. Is that all right?
Okay.
If you would turn to page 14 of your amended complaint, do you see paragraph 54 at the bottom?
Uh-huh.
It states, quote, Gaiman's May 5th letter, Gaiman's first July 15th letter, McFarlane's July 15th letter, and Gaiman's confirming July 15th letter, former written agreement, end quote. And that's the 1997 agreement.
I'm sorry, yes.
My question to you is, as far as you are concerned, are there any other documents or communications that supplement those 4 letters?
I would have to see what those letters are. Do we have them?
Yes, I will hand them to you. They all have been marked as exhibits previously, and we ought to look at them all together probably. It will be easiest because you may be able to refer back and forth and help explain it to me. They are exhibits number 2, number 19, number 20, and number...
There's one more.
What is that?
My letter of around the 1st of August to Todd.
That would be exhibit 50.
Yep.
If you look at paragraph 55 of your amended complaint on page 15, you state that on August 1st, 1997, that you've not received the Miracle Man materials, etc., etc. Gaiman faxed McFarlane an inquiry letter. Is that what you are referring to?
Yep.
Does exhibit 50 form part of the 1997 a contract or not? Gaiman's lawyer pops in, object, calls for legal conclusion. McFarlane's lawyer pops in. As far as you know, Mr. Gaiman.
I'm not a lawyer. I couldn't say.
In your opinion, I'm asking for what you understand the terms. You were the person that entered into the agreement with Mr. McFarlane. Is that correct?
Yes.
1997, the 1997 agreement.
Yes.
Did you have a lawyer help you with drafting any of the terms in that agreement?
No. Mr. McFarlane stated categorically that he would only talk to me after getting the letter from Melanie Cook, that he would only talk and negotiate and organize something if no lawyers were involved. It was just me and him, mano a mano, 2 guys together. I very much wanted lawyers to sort it out because I figured we wouldn't be in the mess we are in now.
So your answer is no. You didn't have a lawyer.
No, didn't have a lawyer.
So is it fair to say that you drafted these letters back and forth, including your May 5th letter and your 2 July 15th letters?
I drafted the May 5th letter. I then had a long phone call with Todd on the 15th of July 1997 where he phoned me up, agreed to everything, said yes, we had a deal, and went over the points of the deal with me and said we had a deal. What I did in my letter of July 15th was then, from the list that I made, I sat and I typed everything up and sent it off to him. I was incredibly relieved that finally this was all going to be done. Mr. McFarlane on July 15th faxed me straight back to say beauty.
I'm familiar with the letters, with what the letters say. Let's try to do this a little bit more question and answer, if we could.
Absolutely.
My question to you is: did you believe that you had a contract with Mr. McFarlane after you sent back your confirming letter on July 15th, 1997, which has been marked as Exhibit 33?
Yes.
So is it fair to say that the letter you sent on August 1st, 1997, which has been marked as Exhibit 50, was not part of the agreement itself, but simply a follow-up letter wondering what's going on?
Well, and it said at the end, if it isn't going to happen, let me know and we can renegotiate.
What did you mean by that?
I meant if Todd had changed his mind, he had somehow reneged or gone back on the deal, I was perfectly happy to roll up my sleeves and say, okay, well, what do you want? Let's keep going on this until we have something that's a deal, but obviously we had.
But your understanding was that you did have a deal on July 15th.
Yes, entirely.
Let's talk about that deal. In your first July 15th letter, which has been marked previously as Exhibit 19, your third paragraph down, you state, my rights in Cagliostro and Medieval Spawn, as above, will be exchanged for your share of Miracle Man, correct?
Uh-huh.
I would like to ask you about that. What did you mean by your rights in Cagliostro and Medieval Spawn?
I was the creator of Cagliostro and the creator of the derivative character Medieval Spawn. I had...
So what rights did you have by virtue of being a creator of those characters? Gaiman's lawyer pops in. Object to the extent it calls for legal conclusion. Testify as to what your understanding is of those rights. Question from McFarlane's lawyer. Let me clarify. I'm asking you. I have already asked you if you had a lawyer help you choose these words, correct?
Yes.
And you testified that you did not.
Yes.
These are your words?
Absolutely.
So I'm asking only as to your understanding as to those words you chose to use in the documents which you claim from a contract with my client, okay? So I'm asking you what you mean by what you said my quote, my rights in Cagliostro and Medieval Spawn, end quote. And your answer was, I created those characters. My question to you is, what rights did you get by virtue of being the creator as you understood it?
As I understood it, I had an intellectual property, a share of the intellectual property of these characters.
And what do you mean by intellectual property of these characters?
I mean some share financially, and beyond that in who these characters were, what they were as the creator. I had written their first appearance, I had made them up, I created the name of Cagliostro, the character of Medieval Spawn, and was willing to hand everything, as far as I understood, had now handed everything, whatever rights I had in those characters, whatever share of the characters as the creator I had, I was giving to Mr. McFarlane.
And that's my question. I understand that. That hasn't told me what your share is. Did you understand when you wrote this letter on July 15th, 1997, that you have acquired rights in Cagliostro and Medieval Spawn by virtue of an agreement in 1992, or by virtue of your creation of these characters?
By virtue of my creation of them and never having signed anything away on them.
So you did not have any contract in 1992 or any other time that specifically granted you any rights in Cagliostro or Medieval Spawn, is that correct?
No, I hadn't granted Mr. McFarlane any rights specifically.
It's not my question. I'm asking if you ever got any rights to Cagliostro and Medieval Spawn by virtue of any contract.
Can I ask my lawyer something, please?
Let me ask the questions. If your lawyer needs to object, that's fine. You can talk with him. Gaiman's lawyer pops in. I guess I will object. The questions may be vague as to whether you are just referring to written contracts or you are encompassing both oral and written contracts, and I think the witness wasn't clear because of that. That was what I was, McFarlane's lawyer. Your testimony a few minutes ago, and I don't want to mischaracterize it, but I believe this is accurate, was that you obtained rights to Cagliostro and Medieval Spawn, those characters, by virtue of you creating those characters in issue 9.
Uh-huh.
Coupled with the fact that you were not asked to or obligated to sign any rights away under those characters. Is that correct?
Uh-huh.
And is this based on your understanding and based on your experiences with DC Comics that you typically, when you do a contract with DC Comics, even for a character that you've created, you do sign away the copyrights to those characters? Is that correct?
Not necessarily. If it is work for hire and has been previously agreed, you did.
I understand that. Let me ask you a question. Gaiman's lawyer. Let him finish his answer to a question before you interrupt him. McFarlane's lawyer. Have you ever signed a character equity agreement with DC Comics regarding any character in the Sandman series that was not work for hire?
The whole of Sandman was work for hire.
Okay, so it's the work for hire provision in those contracts in which you give up your copyright interest, is it not? Gaiman's lawyer pops in. Object, call for legal conclusion. McFarlane's lawyer comes in. Take a look at Exhibit 58. Please, Mr. Gaiman, excuse me. Exhibit 57. Do you have that?
Yep.
Do you see paragraph 6?
Yep.
And that states that the work created hereunder is a contribution to a collective work and constitutes a work made for hire. Is that correct?
Yes.
Down in the middle of that paragraph, it says, quote, in the event that the work is not deemed to be a work made for hire, then the writer hereby assigns all rights in the work, including the copyright and trademark rights, end quote. Do you see that?
Yes.
And this agreement governs Sandman issues 50 through 73. Is that correct?
Yep.
And you said Sandman ended on issue 75?
Yep.
Is that the type of provision that you would typically see in your experience in contracts with DC Comics, through which you would give up whatever rights you had, your copyright, your intellectual property rights that you're referred to?
I don't understand the question.
You testified that you believed by the fact that you did not sign away any rights to Mr. McFarlane in 1992. You retained some share in the intellectual property rights of those characters or those creations. Is that correct?
Yes.
You testified that that meant you would get a share financially and in other ways. Is that correct?
Yes.
I want to clarify what you mean by that. Do you have any understanding of what a copyright is?
I thought I did when this thing began. I have now realized that it's an incredibly legal thing and would love to have 5 years to learn.
But you've had been publishing copyrighted works for 15 plus years. Is that correct?
Absolutely.
And when you authored American Gods, for example, your novel that's copyrighted Neil Gaiman, isn't it?
Yes.
When you do work for DC Comics, the work for hire, and the work ends up being published by DC Comics, correct?
Yes.
The fact that something gets copyrighted, that the copyright ownership belongs to DC Comics, does not affect your ability to share in the royalties based on those characters. Is that correct? Gaiman's lawyer pops in, object, calls for a legal conclusion.
I do benefit from the royalties.
McFarlane's lawyer. All the work that you did for DC Comics on the Sandman series was copyrighted DC Comics, correct?
Yes.
And you've received royalties, character equity for much of that work as well, correct?
Yes.
So the fact that you did work for hire for DC Comics and DC Comics retained the copyright to that work did not prevent you from receiving royalties based on that work. Is that correct?
Yes.
So you understand that there's a difference between royalty rights and intellectual rights in the work that you do in the comic book industry, right?
Absolutely.
Back in Exhibit 19, when you referred to, quote, my rights in Cagliostro and Medieval Spawn. Now, I want to clarify, are you referring to your contractual royalty rights, or are you referring to intellectual property rights, or both?
I'm referring to all possible rights, as in the line that you just had me read in this, where DC has me assign all rights in the work, including copyright and trademark right, and all other rights to exploit the work. I think that's the same kind of territory that we are talking about here.
But in that DC Comics contract, you don't assume your rights to get royalties, do you?
No.
In other words, you get royalties based on a contract. Is that correct? Specific percentage royalties based on a contract. Has that been your experience?
Sure.
My question is, did you understand that on July 15th, 1997, that you had specific contractual percentage rights at that time in Cagliostro and Medieval Spawn?
You will have to define percentage rights. Do you mean financially?
Financial, the right to participate. If you look at Exhibit 2, I know we're jumping all around here, but these things were taken together, and I think this is the best way to do it. You list out a series of percentages in that document, do you not?
Uh-huh.
Those are royalties, are they not?
Some of them are royalties, some of them are equities, some of them...
Character equity, isn't that a royalty as well?
It depends how strictly you want to define the word royalty.
Is it a percentage of money you receive based on sales of publication?
Absolutely.
Is that how you understand the word royalty?
Yes, but also goes then on into merchandising and licensing, which has nothing to do with sales of a publication.
According to these figures you've laid out in Exhibit 2, which is your letter on May 5th, 1997, and which refers to the quote-unquote basic DC deal, end quote, when you say that merchandising and promotional licensing, you get 15% from publishers' net receipts. 15% from publishers' net receipts, people. Like, keep that number in mind, Marvel and DC artists and writers. Are you referring to an amount of money that the publisher received from licensing particular products?
Yes.
Based on the sale of those products?
Yes.
So it is a percentage of the publisher's receipts based on the number of sales of whatever it is, whether it's an action figure or under other comics royalties. It's simply the number of issues sold, correct?
Not necessarily, no.
What do you mean when I thought this was the simple part of the question and answer, so...
I'm trying to be helpful.
I know that, but I'm trying to make it clear here. So in Exhibit 2, you've listed comics royalties, correct? Creator royalties, writer royalty, right?
Yes.
You have listed a percentage royalty for collected editions, trade paperbacks, etc., correct?
Uh-huh.
You have listed some percentages for character equity, correct?
Uh-huh.
And those appear to be tied to the number of sales of the comics themselves, correct?
Well, the first one is yes.
And then merchandising and promotional licensing, as you've already testified, that's not related to the sales of the comic book, but it's related to the number of sales of particular product that may be licensed, correct?
Not necessarily.
Okay, explain to me how it might be different.
Well, you do a $100,000 licensing deal for, let's say, Stardust, something that I did for DC that was completely creator-owned. And the company comes to DC, or comes to me, and came to DC at that point and said, well, we want the rights to do a Stardust t-shirt.
Can I stop you right there? And I'm sorry for doing this. I want to ask, you made mention that Stardust is completely creator-owned. Is that correct?
Uh-huh.
Is that a comic series?
It was a series I did through DC, yes.
And when you say completely creator-owned, what do you mean by that? Is that work? Is that not work for hire?
No, it's not for hire.
So you retained all the copyright interest in that work, correct?
Correct.
And did you license DC Comics to do publication of that? Is that how your agreement with DC Comics was in Stardust and I?
No, I mean, we essentially signed a contract with them as you would with any publisher, which gave them certain rights.
So was that more like a deal that you signed for a novel?
Closer. There is so many comics. Comics bring so many things to the equation. You have the artist to deal with, you have a lot more merchandising categories, and so on and so forth.
But as to the ownership interest in its...
The publisher has no ownership interest of any kind.
Does the artist get any ownership interest from you for drawing the pictures that go along with your script in Stardust?
Absolutely, 50%.
You and the artist created the Stardust
World.
And entered into a contract with DC Comics to publish that, correct?
Yes.
And as to the ownership interest, you and the artist agreed that there would be a 50-50 split. Is that correct?
Uh-huh.
But that's not the type of deal you're proposing here for Todd McFarlane in Exhibit 2, correct?
What I'm saying is I'm basing the figures on my standard DC deal at that time rather than on the kind of deal that I got with the creator on a project like Stardust, which were immensely better.
I understand. So I'm clear. So we have got your deal. You're proposing terms in Exhibit 2 based on your standard DC Comics deal, which was what we have already talked about as evidence here, at least as far as we know in Exhibits 57 and 58, correct?
Sure.
So under that standard deal in Exhibits 57 and 58, you did not retain any ownership rights. Those were work for hire deals, correct, with DC Comics.
Can you repeat the question again?
Your Sandman contracts with DC Comics, which are the ones that are being referred to as the standard DC Comics deal or the basic DC deal in Exhibit 2, those were work for hire agreements, correct?
They are, yes.
And you have no copyright or trademark or intellectual property rights in those characters in Sandman, correct?
No.
Do you now understand when I'm talking about two different categories of rights that you might have when you use the term rights in Cagliostro and Medieval Spawn in Exhibit 19? What I'm asking you about is there are rights you have by virtue of being the creator of that work that gets published. Is that correct?
Uh-huh.
Has that been your experience?
Yes.
So when you publish American Gods and you retained copyright as creator, you have certain rights as a copyright holder, correct?
Absolutely.
You are free to enter into contract on any terms you can get. Is that correct?
Uh-huh.
And those terms may have varied based on project, who else is involved, your reputation, etc., correct?
Sure.
Is it your testimony that you believe you've retained the same rights, copyrights, creator rights in Spawn issue 9, the Angela miniseries, your portion of Spawn issue number 26, and the individual characters Angela, Cagliostro, and Medieval Spawn that you have when you publish a novel like American Gods?
Sure. They are not exactly the same because obviously there is an artist involved. We are co-creators.
You are co-creators, and you would receive, based on those creations, you would receive whatever rights, copyright law. I'm not asking you to make statements as to what that is, but whatever rights the copyright law would give you as a creator of whatever rights you might share with a co-creator. Is that correct?
Yes.
My question now is, in addition to your copyrights of yours, if you want to use the term creator rights, what additional rights, if any, did you believe you had in Cagliostro and Medieval Spawn on July 15th, 1997?
We have run through a financial interest.
And what is the financial interest in those two characters?
Do you want me to answer your first question, or is that a footnote to it? I'm sorry, you asked me a question I was trying to answer.
Okay, my fault. Let's look back at the exchange for a second. I asked you, in addition to the copyrights or creator rights, what additional rights, if any, did you believe you had in Cagliostro and Medieval Spawn? Gaiman's lawyer pops in. Why don't you read back the start of his answer before you interrupted McFarlane's lawyer? The start of his answer was, we have run through financial interest. And I answered, what is the financial interest in these two characters?
Good. So we have run through a financial interest, copyright interest. What was the other one you said in your original question?
I said in addition to, I don't want to talk about copyright.
No, I know, but you said in addition. I was just running through the ones that we had already on the table.
I just asked you what else you had besides copyright, or I said creator.
I said I had creator interest and a copyright interest.
Excuse me. I don't think it's important to interrupt you here because we have a miscommunication. Oh, let me do that again. Excuse me. I do think it's important to interrupt you here because we have a miscommunication. You use the term creator rights. I use the term copyright. I don't want to be in a position of asking you to state a legal conclusion as to what a copyright is or all your rights intended to it. But so that we understand ourselves, in my view, we are talking two categories of rights. We are talking about rights you get by virtue of being the creator.
Uh-huh.
I don't think it would be controversial to state that among those rights, I think would agree would be copyrights.
Uh-huh.
Okay, that's one category of rights. I'm not talking about those. I'm talking about only if you have any additional rights by virtue of an agreement with Mr. McFarlane or in any other fashion to Cagliostro or Medieval Spawn. And let me clarify that again. It's your understanding, is it not, that by virtue of being the creator of these characters, your interest in the copyright or intellectual property rights that you describe would entitle you to receive financial gain from the exploitation of those characters. Is that correct?
Yes.
And that whatever the financial gain is, you would split 50-50 with the artist who was your co-creator. Is that correct?
Uh-huh.
In addition to the financial gain, in addition to the financial interest that arrives by virtue of you being the creator and nothing else, did you believe on July 15th, 1997, that you had additional rights, any additional financial interest in Cagliostro or Medieval Spawn?
Did I have an additional financial interest in addition to the financial interest that I had in them?
All right, let's do it this way. This is my question, but you get a financial interest by virtue of being the creator. That's your testimony, correct?
Yes.
It's your understanding?
Yeah.
And that financial interest derives from whatever ownership you gained in the intellectual property, correct?
I think that calls probably for more of a legal conclusion than I'm prepared to give.
Your term was intellectual property rights.
Yeah.
You looked at the DC Comics deal and copyright, trademark, and all other rights, correct? Those are the rights that you typically signed away in a DC Comics deal that you did not sign away with Mr. McFarlane, correct?
Sure, but DC, it's all rights including.
I understand. That would be your rights that you would get by virtue of being creator, correct?
Yep.
Let's use creator rights because I want to include whatever you understand that to be. Earlier, you used the term retain the intellectual property in that. The ability to get some financial gain from that, correct?
Yep.
And you also testified that you would have to split that. You would get 50% of that gain because you would have to share it with your co-creator, correct? Let's assume the amount. Let's assume that amounts to a figure of $100
Uh-huh.
as a result of these characters. Okay.
Uh-huh.
That's a financial interest that arrives solely as a result of you being the creator, nothing else. Okay.
Uh-huh.
Now I want to know if, in addition to that $100 that you would get because you are a creator, you believe that you wrote it in that July 15th, 1997 letter that we've marked as Exhibit 19, that you have had a right to obtain additional financial benefit from these characters, or are your rights all tied up in your being creator of this? Gaiman's lawyer pops in. Are you talking about contract rights? McFarlane's lawyer. Yes, I am, but he was unwilling to talk about contracts. I'm just asking in general.
I'm not willing to talk about anything. I really don't understand quite what you're getting at here, and I'm really not...
No, I understand.
I'm sorry.
Gaiman's lawyer says, let's go off the record just for a second. I think we're going to be able to wrap this up in the next one. Jimmy, we're getting deep, man.
Yes, there's a lot to consider there. I think that 15% of net off of characters you create is really interesting, because I don't believe that's the situation now. I don't believe that's the situation at Marvel. It's interesting to hear this. And we know these rights have changed over time, and what these companies are willing to offer in terms of rights whenever you come to them and create a character. But I do think it's interesting to get that out here as a snapshot of what was available in, you know, the mid 90s or the early 90s, whenever they're talking about this net piece.
These are high level creators who bring in a lot of money for the company, gives you a little negotiating wiggle room. What I would like to put out there, because we have a vast audience, we have a lot of people in the comics game who watch this, who correspond with us, who have the potential to leak us some information. Now, we don't need to know dollar amounts, but there are some big time creators working at Marvel and DC right now. Take a look at your contract. Let us know what some percentages are. Maybe in a future episode we can leak that data with no names specifically being mentioned. But I think it's a good idea for people to know what is out there, because maybe it is out there. Maybe you got to be at a high level. Maybe you just need to remove yourself from the negotiating table with CB Zabalski, and you got your lawyer to handle that business, and they somehow magically find this 15%.
Yeah, I am curious about that. I wonder if that's something that changes after Marvel's bankruptcy. Mm-hmm. Rob Liefeld's been very public that he's getting pieces of Deadpool.
Yeah.
So maybe a different contract available in those early 90s than post bankruptcy, or who knows, post Image forming. I have no idea when things would have changed, why they would have changed, how universal it is. The other thing that comes to mind is, I think it's Ed Brubaker who has talked about like Captain America Civil War, the movie, and making nothing from it. I think he may have been an extra and got paid for that or something. I can't remember the specifics, but it's been online. Like, I haven't actually talked to Ed Brubaker. I'm repeating what I've read that's attributed to him online. But I wonder, like, once you get into copyright, like, your copyright is, I wrote this story. The writer of that story has the copyright. So it wouldn't even necessarily be creating a character as much as, like, you wrote a story. Now, you've signed over those rights to Marvel, as Gaiman has described here, as part of your contract with them, but it does call to question, like, what could your agent come in and negotiate?
Yeah.
Could you have a percentage on the story, not even necessarily a character? And who knows? I mean, it's Disney now. Maybe you get 0% of anything. But it is interesting to consider this stuff. And I don't know Brubaker's situation. I don't know if an agent negotiated his contract on behalf of him. I don't know any of that stuff. But these are topics that, why isn't this stuff more known? A bunch of us work in this industry. I've never seen somebody say that 15%, net for all these other licensing.
Yeah.
So I love getting it out there, and hopefully people do know a lot more about it and can add to this, because let's put it on the table. Let's know what's available. Let's go get that high-profile entertainment lawyer to negotiate these contracts on your behalf if there is some room there.
Yeah, absolutely, man. And then we start to get into that murky territory of derivative characters and things. And if that equity deal is not possible at Marvel DC anymore, it does make sense why people just aren't creating characters the way they do. But then other characters do get created, and you have some stars. I'm thinking of Gwenpool. Now, are you going to get into an argument with the creators of Gwenpool that it's just a derivative character? Now you took, I don't know, Deadpool and Gwen Stacy, or is that the
right?
character?
I think that sounds right.
No, Spider-Gwen. Spider-Gwen.
There was a Gwenpool though, right?
I'm thinking about like Spider-Gwen is the white.
Yeah,
hooded, like, that's an iconic character. I seen freaking Air Jordans with those colors and stuff like that. So that's Spider-Man and that's Gwen Stacy. You creators of that, you get nothing. Is that how that plays out?
All of this stuff's murky to me. Like, I go back to She-Hulk, which I believe was created based on the Hulk being a show in Hollywood, and then fear that Hollywood could create a derivative character and have rights to them. So, like, you need to get a trademark on the derivative characters before somebody else does.
Right.
Again, I don't know any of this stuff, except, like, you look at what has happened and you have questions.
Yes.
And I have lots of them on this stuff.
And you know what? We have a lot of questions for Neil Gaiman, and he's coming to town in May. So, Neil, let's do lunch. The emails are out there to your assistance. we will have no conversation on the record or behind the record about this right here. This is something separate. This is an educational experience for Jim and I to go through this deposition. We fully understand that, first off, we don't want to be in your business all like that. And I'm sure you're not allowed to talk about that kind of stuff. So none of this is a part of that.
Right.
There's plenty of other things that we have to talk about.
Yeah, dude, you're a top-level creator. I want to talk about your creativity.
So we are the comic book makers in this town. You're coming to our home. It would be insulting to not break bread with Neil Gaiman. And we definitely don't want everybody in the Carnegie Music Hall to be chanting, Cartoonist Kayfabe. Cartoonist Kayfabe.
I wouldn't mind a hall of people chanting that sometime, to be fair.
But how about the people that paid $100 a ticket?
Maybe not when Neil Gaiman's on the stage.
What if I get a Red Room royalty check-in and I could buy 20 $100 tickets? Or $100 tickets and stack it up with a bunch of homies who are going to be like, Cartoonist Kayfabe.
In Red Room cosplay, no less.
They ain't going to bypass the metal detectors. Man, let's get out of here until next week on Kayfabe Courtroom. What do you got out there?
Join me on patreon.com/JimRugg. Download a bunch of my out-of-print zines and mini comics. See a lot of my original art process, the creativity that I make, how I make the comics I do at patreon.com/JimRugg.
All right, man. Red Room, the Antisocial Network, is in stores right now. The book collection is going hot and heavy, man. At the distribution level, we're dwindling those copies. Every time a new video goes up, man, we sell more and more. So if you see it, you got to scoop it up. Red Room Trigger Warning is going to begin in February of 2022. The issues are all done, man. We're just waiting on the queue at the print facility to make these comic books happen. I wanted to sell the hell out on day one, man, because ransomware attacks prevented stores from ordering, so we're locked into a certain amount of copies we have to publish. It's going to be a rare specimen. You get to all of our links in our link tree in the description below these videos. Jimmy, what else do we have out there?
Subscribe to the Cartoonist Kayfabe e-newsletter at the links below the video. You can also find Cartoonist Kayfabe t-shirts and merchandise at the links below the video.
All right, man. Give them those marching orders, and we're going to be on our way.
Make more comics.
Stay out of jail, goddammit.